Just hang on, because
Okay.
you don't know what month your child's born in. You don't even know what month it is. You don't know where you work.
This case starts off chaotic for a reason, and that chaos matters. From the very first seconds, you can feel the courtroom tension because this is not just about paperwork or technicalities. This is about trust, credibility, and whether the court believes a word coming out of the defendant's mouth. Judge Simpson immediately frames this as a bond violation issue, which is serious. Bond conditions are not suggestions, they are court orders. When someone is released on bond, the court is essentially saying, we trust you to follow the rules while your case is pending. Break those rules, and that trust evaporates fast. What makes this opening especially dramatic is how casually the violation is initially described. The defense tries to soften it. A birthday party, family on both sides, no direct conversation. But legally, no contact means no contact, direct or indirect, intentional or accidental. Being in the same space is often enough. This is where a lot of defendants get confused or pretend to be confused, and judges see this pattern constantly. The hook here is simple but powerful. Is this a genuine misunderstanding, or is this someone pushing boundaries and hoping the court lets it slide? Pay attention to how Judge Simpson listens. He's not reacting emotionally yet. He's collecting inconsistencies. And in a bond violation hearing, inconsistencies are deadly. The entire trajectory of this case hinges on whether the judge believes this was ignorance or disrespect for the court's authority.
Court does call the case of the People versus Alfred Lamar Jackson.
There is a bond violation that we need to address as well when the court is ready.
Yes, let's deal with this bond violation first.
Okay, and I did not receive the report. However, upon speaking with Mr. Jackson, he does admit that there was contact with alleged victim in this case. However, he stated that what had happened was his son had a birthday party. It was a very large event where there were family members from both sides. He thought because he wasn't having direct contact with her at the party that it was okay for him to be there. I did explain to him that no, that would violate his bond. He does understand that. My understanding of what happened was a police officer happened to see him at the party, knew that there was a no contact order, and then arrested him for violating the order. However, I don't believe that there was any new sort of altercation or anything between the parties. So he is asking the court to reinstate his bond. He has been in custody for about 2 weeks now, and he also has no objection to a GPS tether.
Anything from the people?
Happened. So he was driving the vehicle. She was the passenger in the vehicle. They had stopped him for no license. So that was the violation. I'm not sure about, I didn't know about the other violation of being at a party together.
Cleveland?
I, again, have not received the bond violation information. I'm just going off of what my client had represented to me about why he was arrested.
What day was his son's birthday?
It was that Monday, that following Monday. And I got caught in the car with her because I took her to get some decorations from the Dollar Tree, and the officer pulled me over. And I told you that one. That's how it happened.
What day is your son's birthday?
It was.
Really?
It was.
No.
What is the date, not the day of the week?
It was May.
This is the moment where the courtroom energy shifts, and Judge Simpson knows it. Forget the legal arguments for a second. This is about credibility. When a defendant cannot clearly state their own child's birthday, especially in a hearing where that birthday is being used as justification for violating a no-contact order, alarm bells go off. Judges are trained to evaluate demeanor, clarity, and consistency, not just facts on paper. From a legal perspective, this answer undermines the defense's entire explanation. The birthday party was the excuse. If the excuse isn't solid, everything built on top of it collapses. The hesitation, the backtracking, the vague timeline. It all suggests either carelessness or dishonesty, and neither plays well in front of a judge who is deciding whether to reinstate bond or keep someone locked up. This is also where emotional stakes rise. The defendant says he just got back into his child's life. That may be true, but courts don't operate on sympathy alone. They operate on responsibility. If you are trying to convince a judge that you deserve freedom while awaiting trial, you need to demonstrate basic stability and awareness.
He's like, he just turned 1, so it was May.
You don't know your son's birthday?
Man, I just really got back into his life like that. So I wasn't into his life like that. But That's what really happened, Your Honor.
What day was the party?
The party was on a Monday it was I can't remember the days because I've been in here so long. It was May, I think it was May, that May month, that second or the third weekend. I just know it was not this Monday, but last Monday.
Was that May?
So he's been in custody for about 2 weeks. So I believe that would have been March 21st.
Yes, it was March 21st.
Well, I guess my issue is he was ordered to have no contact. I understood what you said, Ms. Kleeman, but I don't know how much more direct contact there is than that. Can I have counsel myself in chambers, please?
Right here, Judge Simpson cuts through all the noise. This is the legal core of the case. No contact means no contact. Not no arguing, not no texting, not no being alone together. It means zero proximity that could reasonably lead to interaction. Driving together in a car is about as direct as it gets. This is where many defendants miscalculate. They assume intent matters more than behavior. In bond conditions, behavior is everything. Whether the contact was for decorations, groceries, or a child's party is legally irrelevant. The order exists to prevent situations from escalating, period. Judges don't wait for something bad to happen. They intervene to prevent it. The bench conference that follows signals something important. The judge has already reached a conclusion about the violation itself. The only remaining question is consequence. Should bond be revoked entirely or modified with stricter conditions? When the defendant admits the violation, that narrows the court's options dramatically.
Okay, record should reflect there's been a bench conference in this case. My understanding, Ms. Kleeman, so that we're clear, he's admitting to the violation.
That is correct, yes.
I'm going to reinstate the defendant's previous bond with an added condition. That is that the defendant will be on a GPS tether. Are you working?
Yes, I had just got a job at Alpha Packing, and I called and update. They said I still got my job when I get out.
You live down on MacArthur?
Yes.
And where's this job?
It's like I forgot where it's at, but it's Alpha Packing. I just started working there through Workbox. I got in there through Workbox, and when I went to jail, that was my second day to go to work. But I know it's over there.
Okay, so how'd you get there the first day?
I had drove there the first day through Workbox. I got the job through Workbox. And I used my GPS to get me there, but I forgot the streets.
I don't even know what to say about that. All right, so you don't know what street it's on?
All I remember is down there by West Willow somewhere. It's called Alpha Packing. You can look it up.
Oh, yeah, I should, huh? Because you can't remember where you work. I'm supposed to look it up.
I'm just not.
Hang on, because
okay.
You don't know what month your child's born in. You don't even know what month it is. You don't know where you work.
This exchange borders on surreal, but it has real legal consequences. Employment is one of the key factors judges consider when deciding bond conditions. A stable job suggests routine, accountability, and reduced flight risk. But stability has to be demonstrated, not claimed. When a defendant cannot name the location of their workplace, it severely undercuts the argument that they're grounded and responsible. Judge Simpson's frustration is controlled but unmistakable. This isn't sarcasm for entertainment. It's disbelief rooted in experience. Courts hear excuses every day, but they expect basic preparation. If you want the court's trust, you show up knowing where you live, where you work, and how to comply with court orders. Legally, this matters because GPS tether conditions require verified addresses and predictable movement. If the court can't even establish where someone works, monitoring becomes meaningless. This isn't about shaming, it's about enforceability. A bond condition that can't be enforced is a liability.
And Your Honor, I believe that address that the defendant stated on MacArthur is also where the victim resides.
Sir, when this case is not going, do you live there with Miss Williams?
No, I was staying with my sister. She stays in the next complex. That's where I was gonna go, or I was gonna give me a room for a week until the case over with.
Oh, boy. So this address is in what, Sycamore?
Yes, my sister stay in Danbury.
They're right next to each other.
And I got other family too that stay in other courts. I can go to their houses, or I can get a hotel room.
Okay. Young man, are you on the lease at Sycamore?
No.
Yeah, I didn't think so. All right. Which means she's going to lose her housing. Potentially. Your sister's at, you said your sister's at Danbury?
Yeah, she stay in Danbury. Like when you first come in around the roundabout, then I got some family that stays in Willow Run. I could go to their house. I got a sister in Belleville. I could use her address. And I got family that stays in Detroit too. But I wanted to stay in Ipsy so the case, till I get done with the case. Or I was gonna get a room for however long the case go up to whatever day it is.
Okay, couple of things. The unit at Sycamore, I'm sure, is a subsidized unit. So he's not supposed to be there. That's why he's not on the lease. Second thing is, if he goes to Danbury, it is likely that that unit also is subsidized and he can't be there.
Now we reach the housing issue, and this is where things get legally complicated fast. Subsidized housing comes with strict occupancy rules. Unauthorized residents can jeopardize not only the leaseholder, but the entire household. Judge Simpson is protecting more than just bond integrity here. He's preventing collateral damage to innocent third parties. This is why the judge keeps pressing for verified addresses. It's not bureaucratic nitpicking. If the defendant is released to an unapproved or subsidized unit, the court could unintentionally cause someone else to lose their housing. Judges are extremely sensitive to that, especially in domestic-related cases. Notice how the defendant keeps offering vague alternatives. A sister here, a brother there, a hotel maybe. Vagueness is the enemy of release. Courts require certainty. An address must be verified, appropriate, and compliant with bond conditions. Until that happens, detention continues.
I don't know where these other, you have no idea where these other ones are. I mean, you don't know the way to work, so you don't have their address, do you?
I forgot my sister address.
Which
but
sister? In Danbury?
Yes, and I got another
Well,
sister.
you can't stay there because your
Okay,
sister. Go
I got
ahead.
I got a brother that stays over there by the Apple Ridge store, but it's in some trailers. I can go to his house, or I can get a room, a whole room for a week until this case is over with.
Here's what I'm going to do. I'm going to indicate defendant admits to the violation. I'll reinstate his previous bond conditions. But prior to release, court has to be provided a proper address that he's going to reside at. All right. So you understand that?
Yes.
So, young man, it can't be a subsidized unit because
Okay, I can go to my brother's house. He's staying like over there by Apple Ridge, and he stay in a trailer. I can go to his house until it's over with, or I can get a hotel room if that's possible.
I know you said that to me about 4 times.
Okay.
So, Ms. Kleeman, I need a
Yes.
verified address. So I'll reinstate his previous bond conditions and previous bond once I have an address and that's been verified that he can reside there. Otherwise, his no bond will continue. All right. So if I can get a written order over, I would appreciate it. And we can get that done, and then I can do the GPS order.
Okay, so give me a call later today, sir. That information for your brother, and I'll get into contact with them, okay?
Yeah, I'm trying to see, because I don't know no numbers, and they got my phone and my property.
May 4th.
Okay.
6th.
Okay. So the sooner you can verify an address for me, the sooner you can get out.
Okay.
All right. Okay. Thank you both.
Great, thank you.
That's it for us this morning. That's enough. All right. 14A stands in recess. Thanks, folks.
This is the final takeaway, and Judge Simpson makes it crystal clear. The door to release is open, but only barely. The bond is reinstated in principle, not in practice. Everything hinges on one thing: verification. Until the court has a lawful, approved address, the defendant stays in custody. That's not punishment, that's procedure. From a legal standpoint, this case shows how bond violations ripple outward. One poor decision leads to scrutiny of employment, housing, credibility, and overall stability. The judge's ruling balances accountability with opportunity, accountability for violating a no-contact order, and opportunity to regain release by complying fully with the court's requirements. The broader implication is simple. Courts reward preparation and honesty, and they penalize confusion and inconsistency. This hearing wasn't loud or explosive, but it was decisive. Judge Simpson asserted control, protected third parties, and reinforced that court orders matter.